Evening, everyone, and welcome to BicTok session 38, our first BicTok session of the year, titled Review of the 2025 CIPAA Case Law and Developments. My name is Michelle, and I'll be your host for today's session. Before we begin, let us run through a few housekeeping matters. Firstly, kindly ensure that your Zoom username reflects the name under which you registered. This will allow us to accurately mark your attendance and, where applicable, issue a certificate of participation as well as for your CPD points. Secondly, if you have any questions during the session, please feel free to leave them in the chat box. Alternatively, you may also choose to raise your questions during the Q&A session at the very end. So to guide today's discussion, we are honored to have with us our moderator, Mr. Chin Yuan Fong. Mr. Chin is a council member of BICA, so we are truly privileged to have him moderate our session today. We're equally delighted to welcome our distinguished speakers this evening. Firstly, we have Mr. Shannon Rajan. He's a partner at Christopher & Lee Ong, whose practice focuses on construction, engineering, and infrastructure disputes, with extensive experience in CIPAA, adjudication, arbitration, and court proceedings. Secondly, we have Mr. Deepak Mahadevan. He's a partner at RV Fazli Maha and Sim, who practices primarily in construction and engineering disputes and is actively involved in litigation, arbitration, and statutory adjudication under CIPAA. He is a qualified adjudicator with the AIAC. Mr. Deepak is also a member of the Bar Council Arbitration and Construction Law Committee. And last but not least, we have Mr. Ryan Su, who is a managing partner of Raikor Law Firm based in Sabah, with a broad dispute resolution practice, including construction and contractual disputes, and who is also empaneled as a CIPAA adjudicator with AIAC and serves as a mediator with the Mediation Center Sabah. He currently also holds the position of Vice President of the Sabah Law Society. So without further ado, I will pass the floor now to Mr. Chin.
Welcome, everybody. Good evening to all. Today, we are delighted to have our three speakers, and they will touch on interesting topics because there are recent developments last year in respect of case law and developments for CIPAA. Now, since the topics are interesting, and I believe most of the participants will have questions to ask, I think I will invite the first speaker, Mr. Deepak, to present his talk.
Yes, thank you, Yuan Fong. Right, can you Yuan Fong, can you see my screen?
Yes, I can.
Okay.
Very clear.
All right. Good evening, everyone. So today I'm going to be covering a number of cases. So if you see on the screen, there are 4 cases that I will be covering. These are cases that were reported in 2025. And the first case is Hoxing Trading. And that is a case, it's a Court of Appeal decision, and it's dealing with the capacity and local standi, particularly on sole proprietors. Then you have Mayfair Ventures Niram Berhad, and that is dealing with late payment interest. And then I'll be dealing with Setia Utama LRT3. That is also capacity and local standi. That's a High Court decision on unincorporated consortiums. And then finally, the Federal Court decision in AIAC against One Emerine, right? So let me get to it. So the first case, Hoxing Trading and Construction, Hoxing Trading and Construction against Hongler Enterprise. So you can see the basic facts on the screen, and what I want to draw your attention to is the fact that in this case, Hoxing Trading and Construction was a sole proprietor. And if you can see on the screen, they were essentially the non-paying party and the respondent in the CIPAA proceedings, whilst Hongler Enterprise was the claimant in the CIPAA proceedings. And for your information, throughout the CIPAA proceedings, that means from the payment claim right up to the adjudication decision, Hoxing Trading was referred to as Hoxing Trading and Construction. So the name of the owner, the sole prop, was not named. when identifying them as a respondent. And that was consistently the case from the payment claim right up to the adjudication decision. So the CIPAA proceedings went along, and on the 22nd of May, they obtained a CIPAA decision. Hongler obtained a CIPAA decision. So what did they do next? In the High Court, they applied to enforce the CIPAA decision, and Hock Seng applied to set aside. Now, in the High Court proceedings, Hongler raised a preliminary objection against Hock Seng's originating summons to set aside. And the ground they raised was the fact that when they commenced proceedings in the High Court, they didn't name the proprietor's name as the plaintiff. Because they are commencing, they should name the proprietor's name. He's a sole proprietor. Now, in the High Court allowed the preliminary objection and dismissed Hock Seng's setting aside application. So what did that mean? Hongler then argued their position was that, look, there's no setting aside application. So since there's no setting aside application, if you look at Inai Kiara, this is a court of appeal decision, if there's no setting aside application, by right, I should be able to enforce the CIPAA decision. But what happened? The High Court dismissed the application. They dismissed the enforcement application, and it's on the same ground, the fact that Hock Seng's name that was identified in the CIPAA proceedings was incorrect. A wrong party was named. And on that premise, there was nothing to enforce because the decision was invalid, right? So both parties appealed against High Court decision in the Court of Appeal. Hongler maintained the same position that, look, my CIPAA, the setting aside was dismissed, so by right, I should be able to enforce the CIPAA decision. Now, this was rejected by the Court of Appeal. Now, the Court of Appeal's position was the respondent, in this case, Hock Seng Trading and Construction, should have been named as follows, which is Chai Hong Seng, in brackets, trading as Hock Seng Trading and Construction, because they are a sole proprietor. So the name of the owner has to be named, followed by the business name. And of course, the logic behind it is that Hock Seng Trading and Construction has no legal personality. So they've got no basis to commence, to be sued as an identity. They are not a valid legal identity, right? And because there was no proper party cited, the CIPAA proceedings were void ab initio. And on that premise, the adjudication decision cannot be enforced or cannot be set aside. The Court of Appeal affirmed a High Court decision. This is Justice Lim Chong Fong's decision regarding naming the proper entity. And Justice Lim Chong Fong, in his ratio, he made it clear that if you fail to name the correct party, it will affect the capacity and the locus standi of the party pursuing the claim, and or even being sued, and even the jurisdiction of the adjudicator, because the proper parties are not before the adjudicator, right? And then the Court of Appeal said this about locus standi and jurisdiction issues. And the reason they said this is because one of the arguments raised was the fact that during the entire CIPAA proceedings, nobody raised any objection about the name of the party, about the entity being incorrect and anything like that. It was only raised in the High Court. But the Court of Appeal basically affirmed the position that just because you don't have jurisdiction, it doesn't confer on you jurisdiction just because the other side didn't object. At jurisdiction, if you don't have jurisdiction, you don't have jurisdiction. And that's an issue that can be raised at any time. So this is not a new proposition of law. It's something that has been affirmed many times. They just reaffirmed it they maintained that the same position in the Court of Appeal. And the Court of Appeal also said that, look, even if the High Court could cure, so this is a comment they made, they said that even if the High Court could cure the originating summons, the High Court judge couldn't regularize the adjudication proceedings because parties were already named like that, right? And it was void ab initio. So on that premise, both the appeals were dismissed by the Court of Appeal. So this case is a good reminder for us if you're a sole prop, we have to be careful about naming party correctly, and that has to be from the payment claim itself, because failing which the entire proceedings can be rendered void, right? Now, the next case is Mayfair Ventures Niram Berhad against Setiakorn Builders. Now, this case, Setiakorn here was the claimant, and Mayfair was the respondent. And if you can see on the screen, Mayfair's claim was for 8.8 million, and it comprised of the unpaid certified outstanding sums, retention sums, and late payment interest. Now, the late payment interests that they were pursuing were basically late payment interests, a standalone late payment interest. I mean, apart from the two unpaid interest for the unpaid certified outstanding sum, the rest of the amounts which form the bulk of their claim were basically purely late payment interest. That means it's a scenario where the respondent had already paid the principal amounts in the previous certificates. Their contention is, for example, if the due date was on 1st of January and they paid 90 days late, they were claiming for the entire duration in which the payment was delayed. So that was a standalone late payment interest that was being pursued. And ultimately, in the second bullet point, you can see that they didn't succeed in their entire claim. Their retention sums was not allowed. And largely, it was two claims, which is the late payment interest, which I'll call LPI, and the balance amount was for the two unpaid certified outstanding sums that was allowed. So the total sum allowed was about 4.1 million, right? Then, of course, parties applied for the usual setting aside and enforcement. Now, in the High Court, there were many grounds raised for setting aside. I'm just going to focus on the one that's pertinent for this case. And that ground is the argument that Mayfair, raised by Mayfair, that the adjudicator exceeded jurisdiction by allowing the late payment interest. Now, the logic behind it was that one of the grounds they raised was the fact that late payment interest doesn't come within the definition of payment under Section 4 of CIPAA, right? But the High Court dismissed the setting aside and allowed the enforcement application. Now, what the High Court said was, when the High Court dismissed the setting aside application, it said that the late payment interest formed part of payment under CIPAA, and payment of principal sums without accrued interest amounts to non-payment under the construction contract. Now, why did the High Court say this? Now, in this case, this was based on the PAM conditions of contract. And there was a clause 30 for late payment interest that allowed the party who delayed in payment, who received payment late, to claim interest, right? So the High Court's logic is, look, the payment claim had already claimed it, the late payment interest. The contract allows for late payment interest. And just because you've paid the principal sum doesn't prevent the claimant from pursuing the late payment interest. And she looked at it as together as payment for work done under the construction contract. And that's how the High Court justified it to be within Section 4, right? In the Court of Appeal, the issue was whether or not the claim for standalone late payment interest comes within payment under Section 4 of CIPAA, right? And the Court of Appeal said that the nature of late payment interest by itself cannot be for payment for work done or services rendered. And then they dealt with the adjudicator's power under Section 25. And they clarified that Section 25O does not extend to standalone interest or unrelated financial loss claims. So then, Satyakon, the other point here, sorry, before I go on to the last bullet point, I think the point that when you see about Section 25O of CIPAA, what you need to bear in mind is that I think the Court of Appeal was referring to a scenario where if you're making a claim in your payment claim purely for interest, you cannot justify it by referring to Section 25O, because Section 25O deals with the power of the adjudicator, and the adjudicator can only award interest for whatever outstanding sum that's being claimed. That's a consequential power that they have to award interest. But if you're claiming as a standalone under your payment claim of interest, it didn't come within Section 4's payment, the definition of payment under Section 4. And then on that premise, there was no jurisdiction, right? So finally, the other point that the Court of Appeal said was Satyakon never claimed for it before issuing the payment claim. And on that basis, it didn't come within amount claimed in Section 5(2)(a) of CIPAA. In this case, as I said earlier, their claim comprised of the pure late payment interest for fully paid certificates and claims for work done with interest. The Court of Appeal the Court of Appeal didn't set aside the entire award. It retained the claims for work done together with the interest claim, but it basically allowed the appeal in part. That means only on the late payment interest that was set aside. That was in a figure of about 1.6 million, and the corresponding interest on that amount also was ordered to be refunded. As a result, the enforcement order was varied accordingly. So that's what happened in the Court of Appeal decision. So the take home from this case is standalone late payment interest is the Court of Appeal has made it clear it doesn't come within Section 4 of CIPAA, and basically it's a core jurisdiction issue, right? And the adjudicator doesn't have a jurisdiction to decide on the standalone late payment interest. Right. Then you have the next case is Satya Utama LRT Sdn Berhad against Siemens Mobility Sdn Berhad. Now in this case, if you can see the screen, Satya Utama appointed a consortium consisting of 3 companies, that is Siemens Mobility Sdn Berhad as SMSB, Siemens Mobility GmbH as GmbH, and Rasma Corporation Sdn Berhad RC. Collectively, they were called the works contractor, and this was involving the LRT line 3 between Bandar Utama and Johan City or something like that. And what is interesting to note here was, although they were a consortium, they all signed the contract separately. I mean, in one contract, and each of them had their own scope of work. And whenever they made a claim, they claim their invoices were claimed separately, right? But when they commence CIPAA, they commence as a consortium together. But in the adjudication papers, they were all 3 companies were named, but it was called as the consortium. It was not a registered consortium. And obviously, Satya Utama took a objection and said that they lacked a local standi. On that basis, the adjudicator acted in excess of jurisdiction. So in this case, essentially, it was a loss and expense claim because of a delay. So the adjudicator proceeded to give a decision in favor of the consortium, and hence the application that was made subsequently in the High Court for setting aside an enforcement. And in the High Court, the High Court took the position that an unregistered consortium is not a legal entity and lacks legal capacity to initiate legal proceedings, referring again to KLIA Associates against Modajaya. So essentially, the CIPAA proceedings here also were null and void ab initio because the adjudicator exceeded jurisdiction when he accepted the consortium as a proper party under CIPAA. So the way the High Court judge justified it is he looked at the words defining aggrieved party, the words defining claimant under Section 4. He looked at Section 5, Section 6 when they make reference, and in Section 8 of CIPAA when they make reference to party. And his lordship then justified it and said that, look, when a reference is made to the word party, it's referring to a valid and legal entity, a registered legal entity. And the consortium didn't come within that. And that on that premise, following the same line of argument in KLIA Associates, the entire proceedings were null and void, right? Also, the High Court affirmed the position that in any event, there is no cause of action because it's a loss and expense claim. Because loss and expense, the High Court maintained, doesn't come within payment under Section 4 of CIPAA, right? So another reminders from the court about entities, in this case was an unregistered consortium, and the serious impact it can have where your entire CIPAA adjudication is rendered void, right? So finally, my last case is a federal court decision of AIAC against One Emirate. And in this case, this I find a very unique case. It is a case, it's actually a simple contractual dispute, non-payment of work done. And if I remember correctly, the figure that's being claimed. So One Emarine was the employer, appointed Ragawang as a contractor for the construction of Emarine Mall and residence. The disputes were for outstanding payments, and I think it was along the region of about 8 million plus that's outstanding. So what happened was payment claim was issued, notice of adjudication was issued. After the notice of adjudication, there was no agreement on the adjudicator. They proceeded to register the case with AIAC, and then they make a request. The claimant proceeded to make a request for AIAC to appoint the adjudicator. Now, AIAC appointed the adjudicator, and once the adjudicator was appointed, One Emarine, the respondent, proceeded to raise its objection towards the appointment of the adjudicator. He raised it to AIAC as well as the adjudicator himself. And AIAC took the position that, look, the appointment was valid. There was no agreement on by parties on the appointment of adjudicator during the notice of adjudication stage, and therefore, pursuant to the request made, AIAC had validly appointed the adjudicator. Adjudicator also took the same position that his appointment was valid, and he proceeded with the conduct of the case and ordered parties to pay the usual deposits. AIC issued the relevant invoices for the advanced security deposits for both parties to pay. And One Emarine objected. They raised their objections and they said, look, I'm not going to pay. I never agreed to the appointment. I'm not going to pay, right? And the adjudicator, as a result, directed the other party to cover the fees pursuant to the AIC rules. Now, what happened while the adjudication proceedings were ongoing? One Emarine then proceeds to file a judicial review application in the High Court. So this is quite interesting judicial review application. Basically, in the judicial review application, what they were asking the High Court was to quash the appointment of the adjudicator made by AIAC on the premise that it was not valid because they didn't follow Section 21 and Section 22 of CIPAA. Now, if you recall, Section 21 and 22 talks about, how parties are supposed to try to agree on the appointment of the adjudicator within 10 working days, failing which then one party can make a request for the appointment of adjudicator. Now, they took the position that the claimant has to propose a name of the adjudicator and then inform the nominated adjudicator of the appointment, and failing which, and until and unless this is done, AIAC cannot step in and appoint. So they took the position that by appointing the adjudicator, it was not valid and that should be quashed. Now, that was one of the reliefs, but there were many other reliefs they were going after, largely against AIAC, where they were saying the AIAC rules itself was invalid. And the premise for that argument was that in CIPAA, I think it's Section 34 of CIPAA, the power to make regulations were under the Minister of Works, not AIAC, right? So on that premise, they said the AIC rules are invalid and correspondingly all the rules on deposits and all that cannot stand. And then another interesting point they raised was AIAC's administrative fee that they are charging is unconstitutional because they say AIC does not have the authority to levy such a fee and it's unconstitutional, right? So all these reliefs were being before the High Court. So while the judicial review application, after it was filed, they also filed a stay application to stay the adjudication proceedings, the CIPAA proceedings, until the disposal of the judicial review. And they filed an injunction against the adjudicator to stop him from delivering the adjudication decision, and Ragawang to stop them from enforcing the adjudication decision. So can you imagine, if you're the adjudicator, you are being sued in these proceedings. AIC is being sued, the other side is being sued, and it's and court orders are being served on you to stop you from continuing with proceedings, right? So what happened here? After they filed all that application, AIAC also filed an application to strike out the judicial review proceedings. And the AIAC's position was on two grounds largely. One was that it was an international organization, and it has immunity from any court proceedings pursuant to IOPIA, which is the International Organization Privileges and Immunity Act, right? And on top of that, AIC contended that under Section 34 of CIPAA, they are granted immunity. I think just now when I referred you to regulations, I was referring to Section 39. 34 is the immunity provision, right? So that was AIC's contention as far as their striking out application is concerned. Now, what happened after that? The High Court gave leave to continue with the judicial review, but dismissed both the injunction and the stay application. One Marine filed an appeal on those applications. The High Court allowed AIAC's striking out application, which One Marine also appealed. Now, the High Court's premise for allowing the striking out application was on the basis that the High Court took the position that AIAC was immune pursuant to the International Organization Privileges and Immunities Act and pursuant to Section 34 of CIPAA. So they couldn't be named as a party, and on that premise, they allowed the striking out application. Now, in the Court of Appeal, AIAC filed a motion in the Court of Appeal to strike out the appeal against AIAC and for an order that AIAC cease to be a party, because their position is they are immune, right? So both the striking out appeal and the motion by AIAC was heard together by the Court of Appeal. And the Court of Appeal allowed One Marine striking out application and dismissed AIAC's motion. So what it meant was that Court of Appeal disagreed with the High Court on this and basically said AIAC is not immune. And what was the premise of the Court of Appeal's decision? Now, the Court of Appeal took the position that AIAC, the immunity given under International Organization Privileges and Immunity Act, was only confined to its role as an international arbitration center. It didn't extend to its role as a statutory adjudication authority. So that immunity didn't cover their role when they are acting as a statutory adjudication body. Similarly, judicial review, they're not immune to judicial review proceedings as well. So that, of course, posed quite a bit of a surprise, and immediately AIAC applied to the federal court, and they obtained leave. So in the federal court, these were the questions that you see on the screen. I've kind of summarized it. The first is whether AIAC enjoys immunity from judicial review when acting as a statutory adjudication authority under CIPAA. Whether statutory immunity can oust the High Court's inherent judicial review powers, and whether AIAC immunity depends on the capacity in which it acts as an international arbitral institution or as a statutory adjudication body. Now, in answering this, the first question was answered in the affirmative, where the federal court took the position that AIAC does enjoy immunity, because the federal court's rationale for this is that although in the IOPIA Act, where the immunity was spelled out, it referred to it as international arbitration capacity in international arbitration institution, but it was also worded as inter alia. And the federal court interpreted that to mean that it is also to cover their role as a statutory body adjudication authority. And on that premise, the immunity extends to their role in that capacity as well, right? And I think in deciding this, the AIAC also dealt with the contentions raised by One Marine about the appointment of the adjudicator. And the federal court took the position that, look, the appointment was valid under section, because there was no agreement by the parties. So AIAC was perfectly entitled to appoint pursuant to the request by the parties under section 21 and 22. And then they also took the position that the AIAC rules were correct. I mean, there's nothing wrong, nothing unconstitutional, or nothing defective of the AIAC rules. It was within the framework of CIPAA. and also the fact that AIC is entitled to charge administrative fee. It was nothing unconstitutional about it. So they dealt with all these challenges that was raised, and on that premise, they said AICs, because all of this, whatever functions they've acted, which is appointment of the adjudicator, registration, dealing with the advanced security deposit, all are the normal functions that AIC exercises in their role as a statutory adjudication body. So there was nothing to show any bad faith on their part for the court to exercise any judicial review on it, right? So when it came to the second question, the federal court declined to answer, and they said that the question itself is misconceived. Of course, the qualification is that so long the immunity is there for AIC, so long as it was done in good faith and they're performing their functions, which in this case was very clearly the case, right? And the third question was answered in the negative because it doesn't depend whether they're acting as international arbitration institution or as a statutory adjudication body. So that's in a nutshell the federal court's decision. I think, yes, I think I've already covered this. So as a result, the appeal was allowed and the Court of Appeal decision was set aside. And I think I'm done. Yes, thank you. I'd just like to acknowledge my colleague, Sharvina, for helping me prepare the slides. All right, thank you.
Thank you, Deepa. So I guess for all the claimants' representatives, they have to do their groundwork in respect of capacity and locus.
Yes.
Yeah. Okay. Moving along, we have our second speaker, Mr. Shannon Rajan. He will be touching on the topic of enforcement of adjudication decisions. Over to you, Shannon.
Thanks. Thank you very much, and a very good evening to everyone who's logged in today. Firstly, I didn't prepare slides, and it was intentional so that you can see the full glory of my face throughout the next 20 minutes. I will be dealing with, I actually come with very good news. I bear very good news about the enforcement of adjudication decisions. So I'll be dealing with enforcement issues coupled together with the setting aside and stay applications. So we will be analyzing some of the cases and the judges' attitudes in relation to setting aside adjudication decisions. And I'm really pleased to read some of the decisions that has come by way of the Malaysian courts. It is pro-CIPAA, pro-enforcement. It's very difficult to set aside an adjudication decision unless there are exceptional circumstances or very clear issues or a novel issue. For example, some of the issues that Deepak had raised earlier. And it looks at the moment as if the Malaysian position, and I can draw an analogy with the Singaporean jurisdiction when it comes to enforcing of arbitral awards, that it is done very quickly, and there is a cohesion in terms of the judicial attitude in enforcement, and it echoes the intent of Parliament that the contractors ought to pay now, ought to get paid now, and the other issues to be argued later. So it's very, very positive and encouraging to see the type of decisions that have come up. Now, the first case I would like to talk about is a case that actually Deepak was involved in. It's called Game On Fun Park, Southern Sdn Bhd, and Bond MNE Sdn Bhd. It's a 2025 case. Now, the brief backgrounds of this case is that the dispute arose from a mechanical and electrical works at a theme park in Johor. Bond performed certain works pursuant to the construction contract and later issued a CIPAA payment claim for a sum of approximately 600,000. And I call game on fund, which is the party who is resisting payment, as GOF. So they resisted payment, alleging incomplete works. They argued thermal comfort issues and losses totaling up to far more than the claim, which is about 633,000. Now, the adjudicator ruled for bond, awarding the adjudicated sum, interest and costs. Then bond sought enforcement under Section 28. And as the story goes, GOF applied to set aside and stay the enforcement. Now, what is very interesting is there was a preliminary objection that was taken by bond, and the court upheld the bond's preliminary objection and found that the GOF's OS was fundamentally defective in that the combined stay and setting aside application under one enclosure is contrary to Order 69A of the Rules of Court. The OS also failed to state the governing provisions in the intitulment, set out the relevant grounds, failed to set out the relevant grounds in the OS itself, and identify parts of the adjudication decision challenge. So a very technical objection taken, and it's being treated almost somewhat like winding up proceedings where your intitulment has to be very, very well or very precisely drafted when challenging an adjudication decision. So this goes into the narrative that the enforcement mechanism is robust in Malaysia. The court affirmed that such defects in an OS cannot be cured by affidavit. A stay must also be filed separately under Order 69A Rule 4 sub 2. As these were mandatory requirements that were breached, the stay and setting asides were actually dismissed outright. Nevertheless, in the abundance of caution, the judge then went on to deal with the substantive issues. The court rejected GOF's natural justice complaint in that the adjudicator had failed to consider the counterclaim for losses. The adjudicator had expressly analyzed in its findings the issue and found that the contract only required bond to install ducting and not FCU units themselves. They made other findings, the judge made other findings in relation to the adjudicator's decision and concluded that any such disputes must instead be pursued in arbitration or at full trial, consistent with the established authorities in NASA Engineering and MCC overseas. After dealing with the setting aside, it then dealt with the stay and enforcement together. The stay application was dismissed for both procedural non-compliance and failing to meet the statutory threshold. And what is important is that the court resoundingly stated that a stay cannot be granted unless the adjudication decision is set aside, which it was not. As there were no impediments to enforcement, the court allowed Section 28 enforcement in full, recognizing the adjudication as an enforceable High Court judgment. Now, analyzing the decision, it reflects a very strict, formalistic judicial approach to CIPAA challenges. The court emphasized mandatory compliance with procedural rules and demonstrated a narrow view of natural justice, and focused on whether the adjudicator addressed the issues rather than whether he reached the correct conclusion. The judgment, therefore, reinforces as the very profound pay now and argue later ethos of CIPAA, making stays very difficult and preserving adjudicators' factual findings. Now, that's the first case. In relation to the second case, we're going to be looking at, similarly, the interplay between stay, or rather enforcement, setting aside and stay. And the next case is actually Excite Malaysia against Greencon Resources 2025 MLJU 1777. So this case concerns two applications. Firstly, Excite's attempt to set aside an adjudication decision under Section 15 and GreenCon's application to enforce the same under Section 28. The High Court dismissed Excite setting aside and granted enforcement. Now, the background facts is as follows. GreenCon was appointed to perform concrete works for a project. A dispute arose over certificate number 26 for the sum of 1.5 million. GreenCon then issued a CIPAA payment claim and obtained an adjudication decision ordering Excite to pay the adjudicated sum with interest and costs. As the normal story goes, Excite did not pay and filed an OS to set aside, and GreenCon filed its OS to enforce. Now, Excite invoked Section 15B, which is denial of natural justice, 15C, lack of impartiality, and 15D, excess of jurisdiction. Basically, they threw the kitchen sink at GreenCon. Now, in dealing with three challenges, the court made these observations, and very resounding and very strongly worded observations. It emphasized that each limb is distinct, and serious allegations under limb C, which is in relation to lack of impartiality, would require clear evidence. Now, Excite's ground did not in substance involve bias, so limb C, which was lack of impartiality, was dismissed immediately. So the threshold is extremely high. Now, the judge went on to say each limb has different characteristics and they are not interchangeable. And the judge warned that parties often conflate limbs B and D, which is natural justice and excess of jurisdiction. And it reminded parties that the Federal Court of Anas Construction had clearly distinguished them. In relation to excess of jurisdiction, it arises where an adjudicator decides the matter outside the payment claim or response, whereas denial of natural justice is when parties are not given an opportunity to address the determinative issue. Now, whether or not there was a denial of natural justice, the court applied authorities such as IRECA, EconPal, and reiterated that natural justice concerns procedural fairness, not correctness findings. Here, the court found that Excite was fully heard and all issues were canvassed, and there were no failure to give Excite the opportunity to address any decisive issues. Now, when it came to the excess of jurisdiction, which actually was the core challenge, it went through the usual definitions of core jurisdiction, competence jurisdictions, and contingent jurisdictions. I will not go into that because of the limitation of time. The court merely held that all there were four complaints about the jurisdictional objection, were well within the contingent jurisdiction, and it's not true excess of jurisdiction. And on that basis, it dismissed the OS for the setting aside. Now, under Section 28, the court restated the enforcement principles, and it said this: if the adjudication decision has not been set aside or stayed, the court ordinarily must enforce it, provided payment deadlines have passed. So again, the high threshold of Section 15 challenges was established. Bias allegations require real evidence. Natural justice allegation does not mean incorrect decisions, and enforcement, as we can see from the judgment, remains robust. I've got two other cases, but I think I will just dive into a very interesting case. And I'll just deal with that first. And if I have time, then I'll go back into one of the other two cases that deal with the interplay of these three sections. And I find this to be one of the more interesting cases. It is in relation to the case of Binastra Able Build and Kumkang Kind, oh, that's a mouthful, 2024 MLJU 3910. Now, the core facts in a nutshell is as follows. A CIPAA adjudication decision was awarded. Sorry, what are the key? All right. A CIPAA adjudication decision was awarded to Kumkang at 1.2 million plus interest and costs. The award was enforced by the High Court and Binastra's setting aside application was dismissed. Now, Binastra then appealed both orders and in the meantime, placed the adjudicated sum in its solicitor's client's account to secure that sum. When Kumkang issued a statutory demand under Section 466 of the Companies Act, which is a precursor to the winding up proceedings, Binastra then tried to get a Fortuna injunction to restrain the winding up petition, claiming that the debt is disputed because appeals are pending, the deposit proves solvency, and a winding up petition would cause irreparable harm to the subsidiary of a public listed company, and there was an undertaking that may nullify the debt. The key issues. So the first issue is, does depositing the money make the petition hopeless? The answer is no. The deposit proves solvency, but solvency is irrelevant once there was a valid enforceable judgment debt. A debtor cannot avoid winding up by simply refusing to pay and parking the funds elsewhere. And the High Court relied on the case of Sime Darby, Charisma, Synergy, and Pacific and Orient, which all held that the appeal does not stay a judgment. A judgment debt ceased to be disputed, and even a solvent company may be wound up if it refuses to pay an undisputed debt. Binastra's proposal to release the money only after its appeal was described as a de facto stay dressed as a workaround, and the court rejected it. Now, the next issue, do pending appeals create a bona fide dispute? The answer again is a no. Following the case of Pacific Orient, Commental, Blue Dream City, Lion Pacific, the Court of Appeal reiterated pending appeals do not revive a disputed debt. A winding up court cannot go behind an adjudication decision that has been enforced unless fraud or illegality is shown. So CIPAA decisions remain binding and enforceable until set aside. Issue C, is irreparable harm sufficient basis? Again, the answer is no. Binastra argued that a subsidiary of a public listed company, a winding up petition would tank the shares and market confidence. And the court held that fears of reputational damage is not special circumstances. These consequences are common to all winding up. The next issue again is in relation to the alleged undertaking to create a legitimate dispute. And in this case, it was held no. The alleged undertaking about additional formwork was already raised and rejected in the adjudication, rejected in the High Court during enforcement and setting aside, and ultimately unsupported by contemporaneous evidence. So the court's decision in dismissing the Fortuna injunction, the reasons can be summarized as follows. Valid enforceable judgment debt cannot be disputed, especially when it comes to adjudication claims, adjudication decisions. Solvency is irrelevant once there's a refusal to pay. Pending appeals do not constitute a bona fide dispute. Speculative harm cannot override a creditor's statutory right. Allowing injunction would frustrate CIPAA's purpose. So the practical and takeaway for practitioners or for clients as a matter of strategy is after enforcement, there is no disputed debt, even when there are pending appeals. Next, depositing money in a solicitor's account does not protect it against the winding up. So you have to be very, very careful when thinking that you can try and circumvent the enforcement procedures. CIPAA's cash flow objective weighs very heavily. And a Fortuna injunction, the principles of which clearly shows the grant is on an exceptional circumstance. The petition has no prospect of success, and the presentation would cause irreparable harm. And neither limb was satisfied. Now, in fact, in this case, the claimant took an additional step to enforce the judgment. But the case law at the moment, as I understand it, is that even after the adjudication decision, it is sufficient to commence Section 466 statutory notice of demand, which is a precursor to winding up. I think that really takes me to 6:20, 20 minutes, according to my timelines, and I'll just pass it over back to the moderator. Thank you, everyone.
Thank you, Shannon. Very interesting. From your first two cases, it seems that the courts have emphasized that the adjudicator has wide discretionary powers in respect of factual findings and contractual interpretations. And also your other case, Binastra, it's very good news for parties who were successful in the adjudication decisions to conduct their enforcement. So thank you again, Shannon. All right, now we shall move on to Ryan, who will be talking about direct payment.
Sure.
Over to you, Ryan.
Thank you, Yanfo. Good evening, everyone. Thank you for joining BicTok number 4. Tonight, so what I'll do is I'll take a slightly different approach where Deepak and Shannon spoke a lot. They shared quite a few cases, but what I'm going to do instead is to deep dive on a single case, which is Kinu Sdn Bhd against the government of Malaysia, which in this case is JKR. Just now we have a participant who asked for contractor, what are the key 2025 CIPAA cases that contractors need to know? I think this is one of the most important ones, and it will be the legal compass guiding subcontractors on how to get paid, and certainly for principals or the employers wondering why the subcontractors are all not everyone's emailing them, sending them letters to get payments. Okay, so before we deep dive, Michelle, next please. Before we deep dive into the Kinu case, just want to revisit what direct payment is. And in this particular Section 30 of the CIPAA Act, essentially Section 30 allows a subcontractor who has won an adjudication to request payment directly from the principal. And the clearest formulation came from the case of cabinet system, where there are essentially 4 conditions. First is that the main con has failed to pay the adjudicated sum. The subcontractor then made a request to the principal to pay the adjudicated sum. Then third one is important, that there's actually money due or owing or payable from the principal to the main contractor at the time of request. And the fourth is that the principal did not comply. Now, once all 4 conditions are satisfied, Section 30 bites, and then the subcontractor can get a direct payment from the principal. Now, next, I want to, with the recap done, let's talk about the actual case that we have. Next slide, please. Okay, this is in relation to a 110-bed hospital in Terengganu. This is a case where there is the government of Malaysia being the principal, and JKR appointed Nukima Sdn Bhd as the main contractor, and then Nukima appointed Kinu Sdn Bhd as the subcontractor. Just for my own safety, Nukima sounds dangerously close to something else, so I'm not going to repeat that. I'll just refer them to as main con. Okay. Now, next one, the facts. The situation is a very classic one. There's a construction contract. The subcon did the works, but did not receive the payment. Then, number 3, the subcontractor commenced CIPAA proceedings and won the adjudication, got an adjudication decision. They wrote to JKR asking for direct payment, but JKR said no. And the reason, also classic. So the first thing that they said is, I don't know who the subcon is, and there's no privity. The second one is, so that ties into the no consent, and the second one is that there's no payment due. So what did the subcon do? The subcontractor then sued JKR. They filed an OS, naming JKR as a defendant, and interestingly, at the High Court, JKR was successful, and then the subcontractor appealed to the Court of Appeal. Now, next. So the legal issues and arguments were, as I mentioned just now, and the next one. Now, the no consent and the appointment of subcontractor and money already paid. These are side issues, but I'll touch on them as well. But the one with the biggest impact is the last question, whether the amount is due or payable. And I'll go through each one of them. Then next slide. Okay. So this is an interesting one. Because in JKR, or in fact most PAM contracts as well, there is this thing called the nominated subcontractor. And nominated subcontractor is someone that establishes, so with a nominated subcon, it establishes the privity of contract between employer, the main contractor, and the subcontractor, allowing certain payments to be made directly from the employer to the subcontractor. Now, in this case, JKR said, no, I never gave consent to the main con to appoint the subcon, and so I have no privity, and there's no obligation to pay to the subcon directly. So what the Court of Appeal did was say, no, this argument does not fly. If we look at the definition under CIPAA, the principle does not, so definition of principle is just on the chain of payment. So it's just whether there's any payment due, and whether there is consent or not, it doesn't matter. And in this particular case, because it involves the government, there were administrative circulars as well. And even then, the Court of Appeal said, it doesn't matter. Your administrative circular is just your administrative stuff. It does not override the law. Okay, the next one is also an interesting point where the JKR said, okay, and in this case, the specific work done by the subcontractor is for IBS system, industrialized building system, basically the walls and everything. And in this particular case, the subcontractor completed the IBS and certificate was issued. JKR actually paid the main con for the IBS systems, IBS works. So JKR said, no, I already paid for IBS under in this issue the IPC 79 Progress Cert 79, and there's no reason why I should pay for the IBS twice, JKR argues. And the court said, sorry, you're completely misunderstanding the point of CIPAA. The CIPAA, again, it does not really, it's not the issue of direct payment is not really related to the works done. Once an adjudication decision is given and the subcontractor applies for direct payment, then the only question is whether, then we go back to the cabinet case, and then in this particular, the relevant matter is section 30 sub 5, where there's a question of whether money is due or payable. So as long as there's money due or payable to the main contractor, this applies. So it doesn't matter if this particular item has been paid previously. Next one. Now we go to the actual crux of the matter. And this is where it's very, very important for the contractors, or in this, I suppose, more for the subcontractors. Okay. The very interesting thing, I suppose, the key issue number one, key decision number one is that the certification means that payment is due and payable. Now, if we look at the progress of a construction contract, it makes sense. So once work is done, you go through the certification process, and once certification is done to verify that the work is completed, then payment is due. That makes a lot of sense. And in this particular case, the Court of Appeal says that entitlement exists. Okay, the next one, then it ties in. So just now we talked about the certification being done, and then the entitlement for payment exists. Now, in a lot of contracts, there's also this thing called the retention sum. And retention is money carved out from certified works. Typically, it's about 5%. So in typical progressive, let's say it's a 5% retention sum. If the certificate is for 100,000, then 5,000 will be taken out from that particular progress claim and be accumulated into the retention sum, which is normally then released upon, depending on the contract, it could be CPC or it could be CCC in the end. Now, what is interesting is the Court of Appeal said, as I mentioned just now in the key holding number one, once the work has been certified, the payment is due or payable. So either one is either due or payable. And even if it's a deferred release, deferred payment, it is still due or payable. So this particular finding has wide-ranging implication, where the principal or the employer cannot just say, "Oh, it's under retention sum. I don't need to release it to you." So this finding essentially says no, subcontractor does not have to wait until the end of the retention period. So next one. Now, JKR also has a lot of other arguments where in this case they say no, the work was not completed, and there's I will roll on this, but there's 0.14% of the work that has not been completed. And therefore, JKR said they would terminate the contract, and it has taken them a while. They admit that 14 months, but they were still pending a termination cost certificate. And there were issues with the admin work. And the Court of Appeal was very strict. They say, look, so remember section 30 sub 5 says money has to be due or payable. And the reason why JKR is making this argument is that they're saying there's no money due or payable because I'm forfeiting the entire retention sum. And in fact, because there's a termination cost certificate, there will be money payable from the main con to the employer. And the Court of Appeal said, no, cannot. I don't buy this argument. You have taken 14 months and still you have not produced the termination cost certificate, and your delay is your problem. Okay? A delay, your administrative delay is not a legal defense. So, too bad. And the Court of Appeal actually say they would draw adverse inference on the principal, which brings us to the next point. Okay, the burden shifts to the principal. So once you've established, once the subcontractor has established that there's an adjudication decision and they're asking for the non-payment, they're asking for the direct payment, the burden shifts to the principal. Now the principal becomes the person who has to say there's no money due. And they cannot just say there's no money due and that's it, and call it a day. The principal actually has to prove that there is no such payment due. And if you don't, as in this case, what can happen is the Court of Appeal or the court can draw adverse inference, say that's not good enough, you still have to pay. Okay. Right, next. So four key findings as well as the previous preliminary findings. And let's skip this and want to go to the practical impact on the industry. So just to summarize, for the subcontractor, and this is the most important part, is that now retention is something that you can actually go after. You have a much stronger leverage to secure a direct payment. And Section 30 requests are much more enforceable now. Okay? And even if that particular item has been paid, it's not defense, as long as there's other money payable, or if the principal is not able to prove that there's no payment due. Now, for the principal, for the employer, you have a much more difficult task. The burden will then rest on you to show that there is no payment due or owing to the main contractor. And you cannot just say there's no payment due. You actually have to show the statement of accounts, or the best one, if you have, will be the statement of final accounts so far. And if you don't, you have to show this actual dispute. And not just say, you have to show that there's arbitration being commenced or there's pending litigation. So it is no longer good enough for you to claim that there's no money paid, no money due or owing. For the main contractors, in this particular case, Nukima, Simran Berhad, so the delay by JKR in issuing the termination cost certificate becomes a delay that is payable. It becomes a delay that can be attributed to the main con. So it's in the benefit of everyone to speed up the entire process. And in the end, next one. So in the end, the decision by the Court of Appeal was almost R1 million was awarded to the subcontractor, including cost of 20,000 against JKR. So if I were to sum up the entire case in a single phrase, is that retention sum is now fair game. Don't have to wait for everything. And you don't have to wait for the conclusion of the entire project before you can claim for the retention sum for the subcontractor. And for the principal, if you receive a Section 30 sub 5 direct payment application, go through the entire process. There is Section sub 2 letter that is supposed to be issued to the main contractor, and also if all things fail, you can have a set-off against the payment due or owing to the main con under Section 30 sub 4. So look through all the documents. And that concludes my session.
Thank you, Ryan. Well, Kinu is a good case for subcontractors then.
Yes, it's fantastic for subcons.
Actually, your Kinu case, I think we can link it to, I think the first question which was posed in the chat group. This is something about direct payment also. Have you guys seen it?
Okay. So in this question, the subcontractor performed the works under the subcon, and then after that, the main contract between employer and main con has been terminated. And the main con issued a letter to say to wash their hands and tell them to deal with the employer. Okay. Yep. So it does look like a typical construction contract. So as long as there's a construction contract in writing and you have completed the works, then the subcon can initiate a CIPAA proceedings against the main contractor. And the main contractor, once they have the adjudication decision, the subcontractor can then go to the go to the principal, the employer, for direct payment. Now, in these circumstances where they have assumed liability, I would say, so the question is, can the subcontractor file a CIPAA claim against the employer as a respondent? Okay, interesting, but I would say unless there is a proper deed of, unless there's a proper assignment, there's no mention of the assignment. Yeah, unless there's a proper assignment, I would say it would still be best for the subcontractor to initiate a CIPAA claim against the main con, and then the subcontractor can still get a direct payment from the employer.
Sorry, just to jump in, because it then talks about question 2. The position of the main contractor is I've been terminated, and therefore why are you coming to me in relation to direct arrangement between the subcontractor and employer? I think how I would approach this if I was trying to canvass a claim before CIPAA was to try and argue that the conduct between parties, being the employer and the subcontractor, culminated into an agreement. Now, of course, Section 2 talks about a written agreement, and that conduct would be evidenced by the correspondence between the parties. And by piecing together the correspondence between the parties, that becomes an agreement in writing. Though it's not ideal, but then you have a contract to put your legs into CIPAA, and thereafter, I think the default mechanism for payment, if the payment terms are not clear, would kick in. So it's going to be difficult because you're piecing together the terms by way of conduct, evidence in correspondence, and that's your leg in through Section 2. And then the terms are to be distilled from the correspondence, and in the absence thereof, then looking at the default mechanism for payment. That's how I would couch it.
Just to add on from what Ryan and Shannon said, because the scenario also talks about circumstance where the employer terminated the main contract, and now what happens with the status of the subcontract. So because it's a general question, but it's quite common in many standard form conditions, when the contract between the main con and the main contract is terminated, the subcon is automatically terminated. The subcontract is automatically terminated. So you need to be careful. Look at your conditions of contract, because if your conditions of contract has such a clause, and that means the main contract is terminated, your subcontract immediately is terminated. That means your recourse against the main con will be up to the date of the termination. And thereafter, the question, like what Shannon has said, whether you actually can build a case, because under CIPAA is all about written contract. If you can piece it in a correspondence wise and say that, look, I have a contract, that's really subjective and depends on your evidence. But that's a way to look at it. But just another perspective in terms of the termination part.
Okay. Deepak, there's a question directly.
Yeah. Yes,
Oh,
that was a good question by Daniel. Daniel, thank you for it. Number one is that the case does not say that. It's actually stated in one sentence: no cause of action and loss and expense. There's no elaboration about it. But just to so I think the question is the decision that this allows claims for loss and expense. Is it a blanket decision for all such claims, including claims for prolongation costs arising from delays caused by the non-paying party? So the answer is it is not stated in the decision. The reason for that is because the judge had already found that because the entity is wrong, everything is void ab initio. So he didn't discuss the reason why he said the loss and expense is not under CIPAA. But I just want to tell everyone that there is a string of cases in the High Court that have taken the position that loss and expense does come within Section 4 of CIPAA. For example, in Pintaras against KKH Development, Syarikat Bina Darul Aman. But there's also another set of cases that have taken the position, I think it's Justice Wong Keng Keong's decision in Integral Acres, that have said that loss and expense do not come within Section 4. To my knowledge, this has not been, there's no written judgment in the Court of Appeal resolving this conflict. But that there is still room to argue that prolongation cost claims can be within Section 4 of CIPAA.
Thank you, Deepak. I think we have time for just one last question, which is addressed to Ryan.
Yep. So the question is, would I say the case of Kinu applies to a construction contract, although it is not filed under CIPAA? The short answer is no, because this specifically, the Kinu case specifically interprets Section 30, sub 5 of the CIPAA, and it talks about, so if you read the decision of the Court of Appeal, actually interprets the phrase due or payable as opposed to due and payable. And there's a little distinction drawn between direct payment as opposed to a garnishee proceedings, which is similar but not quite. So I would say no. Unfortunately, if the case is not filed under CIPAA and you're not enforcing by way of direct payment, specifically under Section 30 sub 5, Section 30 of CIPAA, I would say that would not have a much wider implication.
Thank you, Ryan. All right, ladies and gentlemen, I wish to thank the speakers for their time and effort put into this talk. And I will hand you back to Michelle for some closing remarks.
Thank you. So thank you very much to our moderator, Mr. Chin, as well as our panelists, Mr. Shannon, Mr. Deepak, and Mr. Ryan for their insightful discussion. And thank you to all of you for joining our first session of the year, BicTok Session 38. And our next BicTok session will be held on the 11th of February 2026 on the topic Resolving Sport-Related Disputes, the Way Forward. So do keep an eye out on our social media pages and website for updates on this, and we look forward to seeing you then. Thank you once again, and have a pleasant evening, everyone.